Hello, dear friends, and welcome to our webinar. That is a webinar series of the webinars, which we run together with experts of Medical Center IVMed and experts from IVMed Family Agency. Today we have invited speaker, invited expert, Olga Danchenko. Olga is experienced lawyer and she will help us today answering questions regarding the surrogacy contract, very important topic and I think the most important point in the whole process, surrogacy process. So the topic today is effective surrogacy contract structure, essential terms and principles. My name is Nadia Milenevska. I'm a director of IVMed Family Agency, and Olga Danchenko is a lawyer. Olga is an expert in conclusion contracts between biological parents and surrogate mothers. She also successfully performs exit process for couples who take part in surrogacy programs with the IVMed Family Agency. So today we are going to discuss what a proper contract with a surrogate mother should include. Of course, we will discuss the structure of the contract and which important points you should obligatorily include in this contract to make process successful. What rights and obligation of surrogate mothers and of course of intended parents, and what you should check, what your lawyer should check before you start surrogacy process, because of course we have some legal limitations, some requirements which couples should correspond starting the program, or even being accepted for surrogacy program by medical center, by fertility center, which will be obliged to fulfill the embryo transfer to surrogate mother. And what power the surrogate mother has over the baby's fate. It's also important, and some points of the contract also may reflect this. So let's start. And Olga, the first question, because we want to build our discussion today in the form of questions and answering, it will make more easier understanding of some difficult points of surrogacy contract. And the first question is, in which form should the contract be concluded?
Hello, everybody. Thank you very much, Nadia, for your kind introduction. So welcome this little mystical Friday routine. Hope it will not affect our meeting today. And I will try to answer questions in as full as possible. Though some of them are not so straightforward as we would love them to be, because surrogacy is rather a developing phenomenon, and we lawyers are trying just to build out legislation in practice in the way to safeguard the interests of all parties and to keep the balance of both parties in best way, but not always perfect. And for today's meeting, I took real contract and just answering the question, in which form should it be concluded? Of course, it should be notarized. And I shall stress upon that Ukrainian legislation doesn't have any clause on the form of surrogacy contract, and only instruction on procedures for assisted reproductive technology has referral that to start surrogacy process, the couple should present to the clinic notarized copy of written contract between the parties. But in order to make a notarized copy, the contract itself should be notarized, and it would not be sufficient to make it just in written form.
Thank you. The second question is, what main points should contract with a surrogate mother include?
Now we shall name the main clauses which are strongly recommended for each surrogacy contract. Though there is no sample or the must form for the contract, we really recommend that the contract includes the following. Of course, the parties, and not just names, but we have to identify the parties in as many details as possible with passports and passports validity and address and so on. And even the first page of the contract, it includes the names of the parties. It describes all information about them in order to enable smooth surrogacy exit process at the end. The subject of the contract should be also named correctly in order to avoid possible speculations about human trafficking. So not to make the baby subject or object of the contract. It is gestation of pregnancy, which resulted from transfer of embryo of the woman from IVF procedure. Rights and obligations of the parties, we shall discuss them in details. Financial conditions. This item, Nadia knows, is the most negotiable part of each contract. Both parties look definitely at this page of the contract. Responsibility for contract violation, of course, and in the view of the fact that a lot of surrogacy programs, not most, but a lot of them are done with intended parents who come from abroad, so foreign citizens. It is very important to set forth applicable law and settlement of disputes, to which court the parties of the contract should apply if something happens wrong. Term of validity, if the parties can terminate the contract or not, and at which stages. Surrogacy deals with very private, very intimate part of our life, and of course contains a lot of confidential information. Confidentiality clause is very important, and the parties are welcome. This is type of civil contract where the parties are welcome to introduce their own statements, guarantees, and so on. So financial clauses are just a field to the parties to complete according to their wishes and desires.
Thank you. So who are the parties concluding the contract actually? And is the agency or other third parties should be mentioned there?
Actually, the parties in Ukrainian practice, the parties of the contract are the surrogate and the intended parents. So we are not in the USA where the agency should be a part of this contract. And of course, a donor, according to Ukrainian law, is anonymous and is never a part of surrogacy contract. And if the intended parents cannot come to Ukraine for some reasons in person, there is a possibility to sign the contract by power of representation. It means that the intended parents can do a power of attorney, which should be notarized. And if it is done not in Ukraine, it should be apostille. And on the basis of original of such power of attorney, the contract can be concluded by representative of the intended parents and the surrogate mother. But the party of the contract should still remain the intended parents. The representative only signs it on their behalf.
Thank you. Maybe, Olga, you can mention also some requirements of power of attorney, because sometimes we receive some examples, which sometimes parents missed a term until the term of validity of this power of attorney, etc.
Yes, it depends on a specific of notary execution of documents in different countries. And we have seen different rather curious situations when we send a sample and the notary even does not review and certifies the document as it is. So it is important, as in the contract, to name the people who give authorization, to name also the people in whose favor authorization is given, because I have seen the power of attorney without names of representatives. It should include all steps for which the person is authorized to sign the contract with surrogate, or at least to sign the contract in the field of assisted reproductive technology, and all other authorizations. And it should include the term of validity. And it should be also signed by the people who give the power of attorney, because I have also faced several powers of attorney from Germany, where there is a law that the original is kept in the file of the notary, and the notary gives only a copy. So it is unfortunately not acceptable for Ukrainian authorities. They should need personal signature of the people. And this power of attorney should be apostilled anyway and sent in original to Ukraine. And no matter if it is executed by each of the couples separately or joint power of attorney, this is okay for Ukraine, both variants.
Thank you. What are the rights and obligations of the surrogate mother?
When we speak about surrogacy contract, of course, a lengthy part of it are obligations of the surrogate mother, because it is not an easy process. It is a great responsibility. So her obligations start with providing full information about her, about her family, about her past pregnancy, her children, marital status, all accurate information. Another part of her obligations is, of course, to comply with all medical requirements, to strictly follow all prescriptions of doctors, to take all medical drugs and injections, to appear timely for all medical appointments in medical institution which is set forth by the intended parents, to inform the intended parents or their representatives about all deviations, about all suspicious things or changes in her state of health. So this is very important for smooth course of pregnancy. And another block, so-called block, because I cannot citate all of the obligations of surrogate mother, which we can see in the real surrogacy contract. Another so-called block is, we call it prohibited conduct. So of course, we understand that the surrogate mother cannot smoke and take drugs, but not only this. There are a lot of examples of these actions which she can do when being pregnant. For example, some contracts which I have seen, they do not allow to consume wild mushrooms, for example, or raw or partially cooked meal, or to avoid heavy physical activity, to take hot sauna and something like this. In our new circumstances of COVID, we would also recommend to include in the contract prohibition to, or just not prohibition, obligation to follow all rules of hygiene and to wear masks to avoid crowding, and obligation to undergo COVID testing where necessary for the surrogate mother. What else about obligations of the surrogate mother? Very important to fix in the contract that she should cooperate on all steps of birth registration and surrogacy exit process for the intended parents. Because if for Ukrainian birth registration, it is only necessary to sign one statement after birth, sometimes there are a lot of, there is a lot of other documentation like declarations, affidavits, and personal visits sometimes to the consulate, answering calls from the consulate before the intended parents get a travel document for the baby. And even for some countries, the surrogate has to cooperate after the intended parents get home with the baby. such countries which do not recognize surrogacy in full, like Germany or UK or Ireland. And in such countries, adoption or guardianship process, different processes in different countries are needed. And the surrogate has to come to the notary to sign again and again some paperwork. So she should be aware of this, and she should be prepared to sign obligation to cooperate until rights of intended parents, parental rights, are fully legitimated by foreign law. And of course, the surrogate, we cannot speak only about obligations of the surrogate, although it is very important. Of course, she also has rights, and she has right to be aware of all medical details of procedure which are done about her body. And she is entitled to get specialized obstetric care throughout pregnancy and delivery. And maybe the most important, to receive reward, financial reward for fulfillment of her obligations. So that is in brief. But this clause of the contract is always, it contains a lot of items.
Yeah, thank you. Is the surrogate mother legally limited in her action? What can and what can't do she do?
I have already told it, because the contract really have to include these limitations in actions, because we need to think about health and well-being of the future baby, but we still have to keep balance of interests and rights of all parties. And legally, the surrogate cannot be limited in her basic human rights and freedoms. But in order to ensure best interest of the baby, of course, her actions are sometimes limited, as I already told. Her daily regime and her nutrition also, and place or where she lives, because at some stages of pregnancy she has to move, in our situation in Kiev, closer to best maternity care and so on. And of course, we also have to think over how to protect the rights of the surrogate, of intended parents, and of the future babies. So there should be balance of interests, and she cannot be restricted in her rights severely, just like this.
Yeah, and maybe we will later discuss regarding the abortion, because abortion, it's a painful moment for both sides, and of course each side wants to protect their rights in this field, and of course it provokes some limitations and some requirements, of course, before taking this decision.
Yes. So now we are speaking about the general cost of pregnancy, when she needs to strictly follow some rules to keep diet and to sleep. So, but not about special things like abortions. A little bit later about it.
What are the rights of and obligation of intended parents?
The intended parents also enjoy rights and obligations, of course. So speaking about their rights, we can note that they have rights to know everything about state of health of the surrogate and their future baby. They can meet the surrogate in person, they can visit her, and they can get all details and have unlimited access to medical data of the surrogate and the baby. And about their obligations, well, classical obligations are to make payments for all the stages of surrogacy process, from medical expenses for IVF, for pregnancy, and for delivery, and if some hospitalization, to pay all associated extra costs. They have to pay for logistical services of relevant surrogacy agency, and for legal services, of course, and to make all payments to the surrogate. And their main obligation is to finally to take custody of the baby, which will be born, and to perform all steps for birth registration of the baby. And speaking about obligations, they have to comply with rights and freedoms of the surrogate mother not to interfere. And I have seen some contracts, especially from the USA, even making details that the intended parents cannot prescribe some medical drugs to the surrogate mother other than prescribed by a local lawyer who is observing pregnancy. And in some Ukrainian contracts, I have also seen the clause for the intended parents not to invite surrogate mother abroad for delivery and perform a birth registration there. So here is also a field for imagination and for work of the lawyer to complete these clauses in right way for obligations of all parties.
Mm-hmm. What are the guarantees of intended parents foreseen by the contract?
This guarantee is namely not in the contract itself. It comes from Family Code of Ukraine, which says that if the embryo conceived by the couple is transferred into the body of another woman, so the couple of intended parents are legal parents of the baby. And it means that the surrogate mother cannot have any rights over the baby which will be born. So this guarantee is just transmitted in the clause of surrogacy contract, and both parties of the contract just underline that they acknowledge this provision of Ukrainian law, that the baby, the intended parents are legal parents of the baby. And it is also very important from my point of view that the surrogate mother underlines that she understands and is aware of all risks and is fine about all inconveniences of pregnancy and delivery process, and including C-section, also a lot of disputes about it. And she signs the contract in full understanding of the process. It's very important to include these passages there.
I just want to remind you that we have an active chat. You can ask your questions there. After our presentation, we will answer all your questions. So moving forward, how is the financial aspect represented in contract, or should be represented in contract? How are the payments realized?
Of course, we definitely have to put financial aspect in the contract. Though I have seen some contracts where financial part is only one sentence that the intended parents have to pay the surrogate actual expenses and some remuneration, but I really do not appreciate it because if the agencies, for example, overtake payments from the intended parents and then pay to the surrogate, so the intended parents can ask themselves why these financial conditions are not reflected in contract with the surrogate mother. It's just for consideration. Personally, I am for putting very, very straightforward financial items in surrogacy contract in as many details as possible to answer all the possible situations, like what happens if. So classical financial conditions are final remuneration of the surrogate mother and monthly payments, of course, which are paid after pregnancy is confirmed. Most contracts also include provisions on compensation of travel costs, compensation for maternity clothes for the surrogate mother, sometimes compensations for embryo transfer, confirmation of pregnancy on ultrasound, so different stages. And sometimes also nanny for own children of the surrogate when she needs to be away from home and has to arrange care about children. And attention should be also paid to possible extra payments for this if situation. Like additional compensation to the surrogate for C-section, for multiple birth of twins, for example, the intended parents have to overtake obligation for hospitalization, disbursements, and some medical drugs. And they have to be prepared to pay some compensation to the surrogate mother for eventual operative treatment in course of pregnancy, which may be needed. And we also have to pay attention to set situation for complications in course of pregnancy, possible loss of body part in case tube pregnancy occurs, and the worst situation, loss of uterus for the surrogate mother. Unfortunately, surrogacy is just a way of medical treatment, and a lot of things may happen, including this dramatical situation. And yesterday we discussed with Nadia that it is very important to reflect all possible ways of early pregnancy termination, to provide some points and solutions for different occasions like spontaneous miscarriage, forced abortion, stillbirth. Usually it is regulated, the extra payments to the surrogate mother according to the stage of pregnancy when this happens. And asking the question about how the payments are realized, different agencies have different approaches to this. And some agencies recommend the intended parents to pay monthly payments, and when baby is born, to pay final remuneration. And even here, we can split final remuneration in two parts, for example. As I already told, sometimes cooperation of surrogate mother is needed not only for birth registration of the baby, but after that for surrogacy exit process. So here we can split first part after signing a statement for registry office of Ukraine, and second part for visit to the consulate, for example. So we have to look at these contracts very individually, depending on legal situation of exit process for each country. And some agencies also split this final remuneration throughout pregnancy. One part, for example, pregnancy confirmation, or 12 weeks, 25 weeks, whatsoever. So it is up to decision of the agency and then the parents and the surrogate mothers. All this can be negotiable.
Thank you. And of course, the question regarding violation of the contract. So what we can consider to be a violation of the contract?
Speaking legally, violation of the contract is a non-performance of some obligations or improper performance. That is why, as I pointed out, it is important to stipulate all obligations in clear way. Then it will be easier so to call proof violation of the contract. If something is written as obligation and the surrogate mother or intended parents do not do it, do not comply with it, it is violation.
Okay. What are the implications of the violation of the contract?
Of course, better not to violate surrogacy contract, because unfortunately it would affect birth of the future baby. But these are ethical considerations. If we look legally at it, so there should be responsibility. And this responsibility, of course, can be also financial. And most contracts contain this item, and they usually foresee responsibility for breach of the contract from the side of the surrogate mother. For example, if the surrogate mother does not agree to move to Kyiv at the stage which is foreseen by the contract, she can be deprived of monthly payments. And if we take the most crucial cases when it turns out that the baby is born genetically related to the surrogate mother, or she does non-authorized abortion, of course, she has to compensate to the intended parents all expenses which they have already paid for the program, including payments of the surrogate mother, medical expenses, so everything like this. But as I already told, I wish everybody that the contracts are strictly followed.
That is why we check everything, the beginning, the intentions, how both sides understand the process correctly, and to avoid all these unpleasant moments beyond the process. And also important, and the question which maybe 80% of intended parents ask us, and we want to reflect it here. It's what happens to the baby in case of the death of the intended parents.
Yes, unfortunately, especially in this COVID circumstances, so everybody has this kind of thoughts, and we are all human, but I cannot tell that there is some straightforward answer to this worst scenario. According to family law, the only legal parents of the baby are intended parents. So the surrogate mother cannot register the child in her name, and she cannot keep the child. So if we see this situation strictly legally, the baby will be considered as baby deprived of parental rights. And unless there are no people who are prepared to take custody of this baby, the baby will go to specialized institution like baby orphanage and will be open for adoption. In order to prevent such situation, we really recommend the intended parents to appoint so-called guardians who will have the power to accept care and guardianship for the baby in such situation. There is no legal framework either in Ukraine or in any other country for this type of document or for this type of procedure. But Ukrainian instruction on birth registration tells that in case of death of both parents of the baby, their relatives are the person and representative of specialized institution for baby care have right to register birth of the baby. So at least this guardian appointed by the intended parents, I would suggest at 12th week of pregnancy or so, he would be able to perform birth registration for the baby, and we will be able to work with him, with Ukrainian authorities, and with diplomatic representation of the country of intended parents to ensure care of the baby by relatives, not to put the baby at risk to go to the orphanage, like this.
How can the intended parents register the baby if the surrogate mother dies at birth?
Another very, very sad situation that nobody would wish. Even today, we had possibility to discuss it with Vital Statistics Office of Ukraine. And again, they confirmed that at the present moment, there is no regulation. It is a gap in Ukrainian law. So if we speak about death of the parents, at least we have this in instruction that relatives or other person can register. If surrogate mother dies and instruction on birth registration tells that her consent statement is needed, for the present moment, there is no ready answer for the procedures. The registry office told us that they will consider this situation and they do not exclude that court decision would be needed for birth registration in such circumstances. But again, only intended parents can be registered as the child's parents. So in registry office or in court, we should protect their rights and get this birth certificate sooner or later.
So maybe that is why it is important to have a correct notary contract concluded, not just a civil contract, but still notarized to use it in court.
yeah, will present all this properly prepared documentation for the court if it happens. I really do not believe that registry office will do birth registration right away. Who knows? Really cannot guarantee, cannot predict now. I can only guarantee that we'll get birth registration at some stage, and wish everybody it never happens. Maybe we'll try to change law a little bit and to introduce this important point for some draft legislation.
Yeah, that would be nice. It would be great, Olga, if you could do that.
Okay.
What causes can the surrogate get? In what cases, sorry, can the surrogate get the abortion? Who can make this decision?
Another dilemma. Of course, so today the questions are not so easy. About abortion. So we have article of the Civil Code of Ukraine, which is called the right to life. And it tells that artificial termination of pregnancy, if this pregnancy does not exceed 12 weeks, may be realized at will of the woman, pregnant woman. In cases stipulated by law, here special medical indications are meant. Artificial termination of pregnancy may be performed during the terms of pregnancy from 12 to 22 weeks. So legislation is very definite unless surrogacy comes to play. And there is no, like in previous cases, no legal framework which tells who can take the decision in such cases of surrogacy. So we are speaking about not urgent circumstances, health circumstances which put at risk life of surrogate or baby, but about situations when some abnormalities are found in course of medical screenings of the surrogate mother, which still allow continuation of pregnancy. So if we look at the family code, we already know that only the intended parents are considered to be the legal parents of the baby. It is very recommended to put this clause in the contract, which will say that in case some abnormalities are detected in course of genetic or other screening of the surrogate, the intended parents have the right to take the decision about abortion or continuation of pregnancy. However, it would not be so easy to enforce such demand in real life because there is no law, not only in Ukraine, but in the whole world, that can force a woman to terminate pregnancy. And it is really unimaginable dilemma, and there may be different solutions. Some people say that it is body of the surrogate and so-called she can do what she wants. Other people believe that if she is gestating a baby which is genetically linked to intended parents, they have the right to make this choice. And in USA, I have seen several cases described in scientific articles where surrogates opposed to decision of the intended parents and kept the babies successfully and still raise these children which have some health abnormalities. So really very, very important question. I do not know, it is easier to find solution for previous questions because they just need some additional points to instructions of birth registration, but here everything is much more complicated. So we can stipulate in contract, but enforcement in real life, and it doesn't concern only abortion, it concerns also reduction of embryos and C-section and all other medical invasive forms of treatment for surrogates. So for Ukrainian doctors, prenatal doctors, the surrogate and is the patient. And only with her signature, they can do some medical procedures. Yeah? So Nadia, as representative of medical institution, she can confirm.
Yes, of course, the central the central point, it's a medical conclusion issued by a doctor, responsible doctor, who monitors the pregnancy of surrogate mother. And if this doctor issues or confirms some specific conditions like genetic abnormalities usually, or some structural abnormalities in fetuses. So of course, in this case, it's a reason to consider abortion. Again, as Olga said, depending on which term of pregnancy, on which term of pregnancy it was detected. And of course, it is important to use a few options, medical opinions from a few specialists. And maybe that is also important to understand, because in notary, in a surrogacy contract, all conditions reflect like what, for example, you can find there, you can read there, surrogate mother should pass the examination in medical facility defined by intended parents, or independent medical facility or specialist defined by intended parents. In surrogacy contracts, it means for surrogate mother that it should be a medical center chosen by parents. For example, medical center IVMed. It doesn't mean independent from medical center IVMed. And of course, if parents want to get the second opinion from other specialists, they should agree that previously with medical center IVMed, for example, because in the end, even if abortion is needed after 12th week of pregnancy, and the medical commission should decide which decision to make to issue permission for this procedure. Of course, they conclude, they accept the conclusion from responsible institution. And if you want to add additional opinion, it should be also considered by specialists from responsible medical facility like IVMed Center, for example. It should not be a specialist who is not actually a specialist, for example, in the field of prenatal diagnostics, because they're all different, have different license. That is why if you want to involve another specialist from another medical institution, please agree that in advance with medical center, with your primary executor for medical services, surrogacy services. That will be the correct way of actions. Okay, it's not so easy, but still. At
the end of our discussion, the questions are more and more
severe. So force majeure, of course, again, it's an interesting point of the contract because everything may happen, and under the condition of pandemic, of COVID pandemic, this point in contract attracts more and more attention of parents. So the question is, what is meant by force majeure circumstances, and how do they influence the agreement between the surrogate and intended parents?
Yes, totally agree with you. So nobody put attention to these clauses at the very end of the process. These are not financial conditions, just, but now everybody is speaking about it. Is COVID force majeure or not? In theory of law, force majeure is a general clause that frees both parties from liability or obligation when extraordinary event beyond the control of the party happens. What extraordinary event can be? So war or military action, revolt, disorder, civil war and unrest, epidemic, natural and anthropogenic catastrophe, changes of legislation, and so on and so forth. But it doesn't mean that onset of these circumstances automatically means that the parties have no obligations anymore. No, As for Ukraine, a special certificate from the Chamber of Commerce and Industry is needed. And the cause and effect link between the event and disability to comply with obligations should be proven to this Chamber of Commerce and Industry. And another question is, which obligations cannot be fulfilled as a result of COVID? I would here in this respect, I would not encourage the intended parents very much that force majeure clause due to COVID would definitely work. So surrogacy contract is special type of contract, and as we say, life has to go on. We cannot stop pregnancy, and the surrogate has to be paid for her services. Here really, COVID may be announced as force majeure circumstances, but how it will affect the agreement and the fulfillment of the parties, not so much.
Yeah. Okay, and of course, maybe something that sometimes doesn't allow to sleep calm at night during the program, but still. What happens to the baby if genetic affiliation test turns out negative?
Yes, unfortunately, it is theoretically, and we have seen already some scandals, and practically possible. And we have to understand that there may be different reasons for this. And depending on these reasons, the results will be. So if it happens through the fault of the surrogate mother, as we already discussed, so then the parents would have the right to terminate the contract, and they will be fully entitled to demand compensation of all expenses they have paid for the process. And if it can also happen through mistake of a fertility clinic. It's also important to determine if the embryos were created in fertility clinic where the transfer was done, or the embryos were maybe transported, whose biological material was used, so whose sperm, whose oocytes, and so on. And I participated in some conferences of where medical practitioners and embryologists were present, and we really can understand that a human factor may happen. So it is just the storage of embryos, they are just stressed with remarks. So due to some human factor, biological material can be mixed. And in such a case, the situation will also develop according to negotiations of the parties, to which conclusion they come according to their desires. It is possible to apply to the court. It is possible to find some amicable solution and to settle this in a more friendly way. Really, a lot of scenarios here may be foreseen by it.
And of course, maybe the most important part is risk management, and of course, your medical center and other contractors like maternity hospital, and then DNA testing, express DNA testing after the childbirth will help to avoid the surprises, of course. And I think if your services providers arrange all in proper way, you have 100%
yes, I
be sure that everything will be
I have heard discussions of embryology that they are working all the time to improve the technologies, to do double check and to do something electronically. They are really concerned about this situation. So really,
thank you.
What happened?
Yeah. Thank you very much, and we can move to questions. We have questions.
I have lost the word.
Okay, so First, hello, is the surrogate mother also an egg donor? Can she change her mind and keep the baby?
The surrogate mother is never, no, sorry, the egg donor. So she is gestating the child which is in no way genetically related to her. And what second question? If she can be registered?
Can
No,
she change her?
No, I already underlined it. According to Ukrainian law, she has no right to be registered. Only the intended parents come to the birth certificate.
Thank you. Hi, can we see a surrogate mother before the program? Will there be choice? I can maybe ask this.
Yes, it is.
Answer this question.
Absolutely possible.
Absolutely, yeah, absolutely possible. So we have no limitations for contacting a surrogate mother. You can have a Skype interview before process start. You can confirm whether you like or don't like the candidate, and this candidate can be substituted with another. So you're absolutely free in this area. Okay, the next question, can my sister be a surrogate for me? Thanks.
Why not? Of course, because there is an age limit only for egg donors, and for the surrogates, for the time being, there is no age limit, but the sister should comply with all requirements of Ukrainian law. So she has to undergo full medical screening and to have at least one healthy baby of her own, and to present documentation on this.
Yeah, thank you. Hi, I was wondering, is it possible to start the process from creating embryos? We are planning to get married in 3 months, but we would really like to start as soon as possible. Thank you.
Marriage certificate is absolutely necessary to present for the stage of signing contract with the surrogate mother. But in my view, it is absolutely possible to start creation of embryos before getting married, if it is the question.
Thank you. And the last question, can we do 2 surrogacy programs at the same time? I mean, with 2 different surrogates to save time.
Yes, Ukrainian legislation does not prohibit it. The only thing we have to understand that it doesn't mean they both get pregnant simultaneously, yes? So all is in God's hands. We can help only with legal and medical part.
Okay, that is all for today. So thank you for visiting us. Thank you for staying with us. Olga, thank you for your informative and very helpful information. I hope to see you in 2 weeks with the next webinar, which we will have. So I wish you strong health and
nice
have a good, have a good weekend. Bye.